All right, welcome everybody. I'm using a microphone not because I have illusions about the size of the room, but because it's being recorded, so be warned, everything you said might be somewhere in there forever. So I am Holger Spamann, I'm a professor here at the law school. I'm organizing this panel together with Jim Greiner, my colleague, who is sitting over there, and Rosanna Thomas, who is a J.D. PhD student at another place that shall not be named, especially not today. Well, Rosanna is doing her PhD in psychology. I did my PhD in economics. Jim did his PhD in statistics. And from those fields, we are used to seeing empirical research, rigorous empirical research all around us. It's just the thing that people do when they want to find things out. And so we are a little bit puzzled and annoyed that we see so little of it in the legal profession. And this panel will want to talk about why that is. And to do that, we are very, very fortunate to have with us Chief Justice Ralph Gants, Chief Justice of the Supreme Judicial Court here in Massachusetts. And we're very fortunate for two reasons. One is that Chief Justice Gants is obviously one of the preeminent lawyers here in Massachusetts and in the nation in general. He has been the Chief Justice since 2014. He has been on the court for almost a decade. He has been a judge for almost 2 decades. He was a partner at Palmer & Dodge before that, and he was an assistant U.S. attorney here in the District of Massachusetts before that. And most importantly, he is a graduate of this law school, and he has taught here. So very fortunate, this first reason. Second reason is that Chief Justice Gants actually does care about empirical work and is thinking about these issues very carefully. Among other things, he asked the law school to look into racial disparities in the Massachusetts court system, something that I'm involved in and Jim is a little bit involved in. We're doing this right now. Now, Chief Justice Gants is our guest of honor, not a co-conspirator, because Chief Justice Gants, we suspect, will disagree with some of the things that we will say, maybe with all of them, hopefully not all of them, but that's why he's listed as a guest of honor, not to implicate him in the kind of things that we are going to say and do. But we'll see about this. So, all right. What's going to happen here in this room in the next 1.5 hours? First, you will have the opportunity to participate in an exercise with your phone. I'll tell you more about that in a second. Then the academics, Jim, Rosanna, myself, are going to describe the lack of serious empirical research in the law. And by serious, we mean randomized trials, real experiments, and we'll talk more about that. We will bemoan the consequences of that lack of research. We will speculate why the US legal profession, the bench and the bar resisted. And then we will also say what the exercise you did in step 1 has to do with all of this. And then the main part of the afternoon is going to be a discussion with Chief Justice Gants, who is going to tell us why the academics are all wrong, or perhaps hopefully not, but we'll see what he will have to say about that. Okay, so that's the plan. Let's start with point number 1. An exercise. It will take about 10 to 15 minutes. It'll require you to read some short materials and answer some questions. It is totally voluntary. You don't have to do it. We think it will be fun, but it's up to you. You can stop in the middle if you want. There's no penalty, of course. We will not reveal your responses or your identity to anybody. After the exercise, we will give you a handout with more information about it. And if you choose to participate and you have questions while you're answering, please hold those questions until we're done with the exercise. We'll talk about it. So the link to the study is on the slide. It's also in front of all of you. There's a QR code for those of you who use this stuff. It'll take you to the site. And I'll stop there and hopefully talk to you again in 10 to 15 minutes.
Criminal cases where the only event precedent is a legal, distinguishable or dicta. Do Do you think judges tend to be guided more by the weak precedent, by their sympathy or antipathy in the defendant, or by neither of the two? Okay. You understand?
I do.
Okay. And so the weak precedent, the options are weak precedent has a strong effect, a modest effect, or no effect on the way judges decide.
I was a prosecutor.
For what it's worth, many people in the room have no court experience at all, and will still be giving their opinions. And you shouldn't be deterred by that.
Okay. That's
Yeah, so it's absolutely. So in criminal cases where the only available precedent do you think judges tend to be guided more by the weak precedent, by their sympathy or antipathy for the defendant, by neither of the two?
If you have an
weak
iPhone,
precedent,
also just like
option
put
choices
camera
are strong
and
effect
camera
of weak
mode at this
precedent,
and it'll give it an
modest
option.
effect of weak precedent, and no effect of weak precedent. Okay, so you would say no effect on the weak precedent, and then strong effect on from defendant's sympathies or antipathies. Yeah, in other words, they're for the defendant, or what they think of the defendant, and sympathies or antipathies. Okay. Continue. Question 2 of 7. Law students working in a school clinic provide representation to unemployment applicants, administering trials concerning eligibility, concerning eligibility for unemployment benefits.
Oh my god.
So unemployment benefits received from law students provide representation for many trials. An unemployment agency employee gathers relevant documents before the hearing, and judges in such cases frequently question parties on their own to elicit evidence. Do you think that an offer of law student representation in such cases measurably increases, decreases, or has no effect on the chance that a claimant is found eligible for benefits?
It's a law student representing.
Unemployment benefits in a mini administrative trial
Whether or not it has any impact.
on the likelihood of success of the applicant.
And the answer
Decreases the chance of prevailing, no effect on the chance of prevailing, or increases the chance of prevailing. Increase the chance. Question 3. A legal services organization matches private family law attorneys working pro bono with individuals who seek uncontested divorces in a large city. None of the divorces involve child custody or domestic violence, and in over 80% of the matters, there are no financial arrangements to make. Do you think that an effort by the legal services organization to find a pro bono lawyer to represent such individuals measurably increases, decreases, or has no effect on the chance that the individual gets a divorce? Choices again: increases, decreases, or no effect? No effect. The next question concerns your opinion on U.S. government policy about regulating terms and consumer contracts. Regulating terms and consumer contracts. The next question concerns your opinion on U.S. government policy about regulating terms and consumer contracts. Contract terms might be regulated, that are subject to regulation, could concern a variety of matters, including what companies can do with information they find on your computer or cell phone, or how your contract rights can be enforced. For instance, when you began the study, you clicked past the terms and conditions of this website. Maybe you're just too loud. case you want to remove your consent to download this history, you have to click here to do so. So imagine you want to find
Yeah.
CFPB, that's the Financial Protection Agency, power to go consumer relationships with financial products and services. CFPB makes it easier for companies to put an arbitration clause in their contract for certain financial products and services. Arbitration clause waives a consumer's right to have their name and disputes in instance of arbitration and action. The CFPB's new rule means that companies are no longer allowed to return to the saying consumers must settle in disputes via arbitration. Do you support the CFPB rule? Please answer this way. 1 to 7, 1 strong opposition. CFPB's rule. These thoughts is 7 strong support. CFPB's rule.
Seven. That's prohibiting.
Yeah, that's prohibitive.
Yeah, prohibiting pickup meat.
Question 5. The next question. Judicial license always be required as condition of
Licensed.
licensed
Oh, licensed.
license lawyers to be required as a condition for any independent law licenses to go at least 20 hours of pro bono week. As part of pro bono work.
Yes.
Next question. Okay. Now we'd like you to judge a case. Okay. Please imagine you're a judge overseeing a case that goes in court. Here's the information. There's a company called Emerging Medium, which has an app that allows users to customize symbols called emojis for their smartphones. Emerging uses a large database of user information to predict which emojis and symbols people are likely to want and monitors keystrokes and Google consumers assume monitoring important keystrokes. Organized consumers will access information far outside the scope needed to create the specialized emojis. For instance, beneath the company, emoji needs to say password, credit card number, or social security numbers. Other information users type out using their smartphone. Emoji means consumers agree to follow the similar keystrokes to services. On the web page, the consumers use to sign up for services. Emoji means giving explicit rights to its privacy policies. And there's a link that shows the screen you would use to log in to the Emoji software. And it's titled, say, by signing up, you agree to the terms of our privacy policy. There's a link that you can use to go see what that's about. The sign-in page, by signing up to agree to terms and conditions of privacy policy provided away. The text of the privacy policy is, you I expressly acknowledge as well as the keystrokes and other non-associated with any use of any use of that information. These are responsible. Under the law, government legally prohibits which are something
No, it's okay.
There's a several descriptions of cases here. conspicuous hyperlink. That is insufficient to ask a question of the contract. Consumers in a lawsuit urging a lawsuit now filed by that lawsuit releases or authorizes the company to information not supplied.
No.
Last question, which is very short. What is your position on the law, formal or lawsuit law? So lawyer or formal? Yes, I'll do these.
All right. Well, thank you to all of you who participated. I'm going to use this again. It does feel a bit ridiculous, but it's going to be recorded. So, okay, sorry about that. So, let us continue. Thank you again. And let us give you a bit of the background of where we're coming from. I said in the beginning that in our observation, there's a very large lack of serious empirical work in law. And by serious, we mean experiments, randomized control trials, and like in medicine. So what is a randomized control trial? A randomized control trial, the gold standard of evidence everywhere. In medicine, in fact, it is mandated by the FDA that new pharmaceuticals be tested by RCTs before they are approved for use with patients. Means that we randomly assign a unit, be it a client, a case, a court, whatever it is, to a treatment or control. So in medicine, that would be we randomly assign who gets the new cancer drug and who doesn't. And in law, it might be who gets the representation and who doesn't. Why randomization? Because when groups of randomized units are statistically equal except for the treatment that we have randomly assigned. And that gives us certainty as much as possible, and we can be more precise about that statistically, that the observed difference, or if there is an observed difference between the control group and the treatment group, is actually due to the treatment that we have assigned in a way that we cannot do with observational data. So observational studies, of course, do exist. I do this myself in law for lack of better possibilities. People do it in other fields as well, but it's very well established that they have much less of an ability to detect important effects than control trials, which is why in medicine, where there are epidemiological studies, RCTs are really the gold standards. In law, we have counted, I don't actually know, Jim will tell me who exactly did this, but Jim assures me that very serious people have counted that there's less than 60 randomized control trials ever conducted in the US legal profession, which compares, of course, to tens of thousands in medicine. All right. Now Rosanna is going to talk to you about the exercise that you just did.
Hi, everyone. Thanks for taking part in that exercise. As you may recall, you were given a welcome screen that looked like this. Does this look familiar? Many of you may have noticed that we allowed you to look at terms and conditions before you clicked through to begin the study. In a minute, we're going to look at how many of you actually clicked on those terms and conditions and how many of you indeed read them. I guess we could do right now, show of hands. Did anyone even notice the terms and conditions box? A few? Did anyone click on it? Maybe one or a few? Okay, great. So had you clicked on it, what you would have seen is a really long list of terms for this Full-Time Pro company. Buried in this list of terms was this long, all caps paragraph. You acknowledge and expressly authorize Full-Time Pro to download and sell your web browsing history and contact list to third parties. I'll stop right here. We are not going to do that, but you did authorize us to do it. We would take your browsing history, we'd look through your contacts and use your contacts for fundraising. We would sell this information to third parties. You agree that Full-Time Pro may, at any time and in any way, reveal that you were the source of the above-mentioned information. We thought that these terms would be unappealing, to say the least, to you all, but we wondered how many of you would agree to them. So this was the initial welcome page. You clicked past the terms and conditions, and then you began answering a bunch of questions. And the main questions that we were mostly interested in your response to were the following two questions. So did you believe that the consumer, in that case we asked you to judge, did you believe that the consumer who had clicked past their own unappealing terms was bound by those terms when they had downloaded their emoji app, the one that authorized the company to monitor their keystrokes? The second main question we were interested in your responses to was whether you support the CFPB's arbitration rule. When we wrote this question, we didn't know that the arbitration rule would be killed the day before. You may have had it on your mind. It may not have actually been the cleanest question because it was in the news, but we were interested in sort of your general attitudes towards regulating the terms of contracts. So the rest of the questions that you answered, remember you answered, should lawyers be required to do pro bono hours? Which effects do you think came out in various other studies we've done? Those questions, we're interested in your answers to them, but we also use them as filler to disguise the main purpose of the study and also to give you a sense of what it felt like to use our app. So we'll spend a little time on those, but those were actually mostly just filler questions. So what was our randomization? You know that we believe in randomized controlled trials. The randomization was that half of you learned before you answered these questions that there had been these unappealing terms that you had earlier agreed to. So who was in that condition where you had the unappealing terms before you answered? So it sort of said, we're thinking of this policy, for example, you just clicked past these terms. For the other half of you, though, you answered those questions, and then at the very end we said, oh, by the way, you clicked past these terms. So our question was, did going through this experience yourself and having it sort of called to your attention, did that affect how you responded to these two main research questions? So yeah, just the awareness of your own perhaps vulnerability or just your own experience with what's called browse wrap, or the terms that you don't actually affirmatively agree to, but that you pass by on your way to accessing a product or something. Does your own experience with that kind of assent process affect how you feel about, does it affect your legal reasoning? So if you're a judge, are consumers bound in this one case? And does it affect, in any sense, your normative judgments, such as, should we have a policy banning these arbitration clauses? So let's get to the results. We'll first look at how many of you even opened the terms and conditions. If you don't open them, there's hardly any chance that you can really assent to them. One might think that you would understand them and incorporate them into your decision making about whether you'd like to be bound by them. And then we'll also look at how you all felt about the privacy policy that the other consumer agreed to, or ostensibly agreed to, and whether it should be binding. So the key question is, did it matter whether you had already been reminded of your own experience with terms before you answered this? Was there a difference of having that called to your attention before? So shall I look at the results? So this is the terms and conditions. So let's see, is there a mouse here that I can mouse over? Oh, I see it. Okay. So if I mouse over this, we can see 5 out of, so n equals 38 means 38 of you took at least made it to this part of the study. So 5 of you clicked on the terms and conditions, and 33 of you went straight to begin survey without even clicking. So right there, we think most of you probably didn't realize what we had asked you to agree to, what you were in fact agreeing to. So the next question is, how did the control condition, these are people who had it revealed to them afterwards, compared to what we called the insight condition, those of you who had been notified beforehand, before you answered the questions about your own experience, you had sort of insight into the consumer experience. How did that affect your feelings of the enforceability of the consumer? So this is actually contrary to our hypothesis, because if you look, those of you who were in the control condition were more strongly pro-consumer. You thought the contract was less enforceable. It looks like about, 68% of you thought the contract was not enforceable without us ever saying anything about your own experience or calling your attention to the fact that you had yourself just clicked through some pretty monstrous terms. And 32% of you thought it was enforceable. And we had thought that you would have even stronger, like the green bars would be even higher among those of you who had just, we had just reminded us happened to you. But it actually looks like the opposite. I don't know if this is a significant difference. We'd have to run the statistics, which maybe we'll talk about. But it looks like it's more 50-50. It's 47-53 among those of you who we said, just a minute ago, you clicked through this before you answered. So this is actually, this is why you do research, right? Because we would have thought we had the opposite hypothesis. Does anyone want to venture a guess as to why it might have come out this way? How about over here?
Yeah, maybe people blame themselves from not reading and for consenting, and that's why they think, in retrospect, that that's enforceable because they feel they had a duty to read, so they assume the risk by not reading. But I would predict. So my intuition was the same as yours before I saw the results. So just an explanation. For what we see here.
Great. So just for the recording, the explanation might be that those who had the insight might actually blame themselves more, feel like they had consented more. Maybe we'll do one more explanation. I mean, maybe that is the reason. Okay. So another thing that we also asked you, these were our filler questions, but we actually have.
No. You're not doing that. Too early. I will add, though, that one reason why the results might come out the way we just saw with the who accepted and who didn't, whether you thought it was enforceable or not, is that these are small groups, and of course there's random chance involved here, and that's why people get PhDs in statistics or take like entire sequences on econometrics like I did, to be able to calculate the probabilities of how this can come about by chance. But that's a separate topic that we won't get into. So we just wanted to give you a sense of how this works, and we just did like an RCT on the fly, so to speak. But as we said, there aren't many in law. In fact, there are hardly any. So what are the consequences of that? The first consequence, of course, the direct consequence is epistemic. Because we don't have RCTs, there's a lot of things we simply do not know, and some of those things are a little bit embarrassing. Are self-help materials in small claims court cost-effective compared to full representation? The self-help materials cost $50 per party. Full representation costs $1,200. We don't know. What methods work to reduce racial bias in court? Some might say, do we even know that there's racial bias in court? We know that there's disparate outcomes, but since the inputs are different as well, we don't quite know that. Are staggered corporate boards good or bad? Any corporate lawyers in the room? That's my field, so we don't know that. It's a very big question. People say there are tens of billions of dollars at stake. We don't know. Do pretrial risk assessment scores reduce failures to appear? So when setting bail, and the question is, how should bail be set? Should bail be set? There are now these pretrial risk assessment tools that are supposed to help judges doing this, with the goal of having fewer people recommit crimes or not appear to the hearing. We don't know if these things are actually effective. I mean, it sounds plausible, but we don't actually know. Legal indeterminacy. How much does the law constrain judges? I still encounter people in academics who think that the law doesn't constrain at all. The judge can do whatever they want. I also encounter people who say that the law basically constrains the judge totally, except when there's explicit grants of discretion. Which one is it, or where in between is it? We don't know. Now, of course, that has repercussions for justice or welfare, whatever your preferred metric. Biases persist because we don't know how to fix them. Legal resources are misallocated because we don't know what actually is cost effective. Money is wasted more generally, and we miss opportunities to do it better. And Jim, that's the cue for you. Doing it better, that's what Jim does.
Well, this is what. Okay. So why do lawyers resist RCTs? And I'm going to offer some speculation on this. First of all, I'm going to try to show you. I think these are the standard arguments that I hear, because 100% of my research time, which, despite the fact that Harvard is a teaching institution, is about 80% of my working time, because that's mostly what I'm paid to do, is trying to talk lawyers and judges into randomized control trials. That's it. That's all I do. And then mostly I farm out the operation of those RCTs, and certainly the analysis I farm out. All that I do is administer and the folks that are doing RCTs, and then try to talk lawyers and judges into it. And my success rate for every conversation that I have in opening a discussion about a potential RCT versus how many RCTs I get in out of the field is about 1 in 20. So about 5% of the conversations that I have result in actual RCTs. And that success rate is so much higher than anyone else's in the universe that they gave me tenure at Harvard Law School because I had a 5% success rate in this area. So there is extraordinary resistance in the United States legal profession, and I encounter it daily. And here are the standard arguments. There's too much at stake. The legal consequences for a domestic violence victim, for instance, there's too much at stake to randomize treatment offered to a domestic violence victim one way or the other in order for us to do an RCT. And then I look back at the folks that are saying that and say, okay, that's fine if you believe that, but we should not randomize cancer drugs. Because do you know what a standard argument is for a standard outcome variable that we measure for cancer drugs? It's death within 5 years. Right? That's an absolutely standard argument. And so that's fine. Let's just never randomize anything, including things that we put in our bodies. In fact, to me, it's precisely because the consequences are there's so much at stake that we need serious knowledge about what works and what doesn't. Another one that we get, it's unfair to deprive the group that was randomized to whatever condition you don't like. And usually with lawyers, it's some group got full representation and some group got something else, like self-help packet or limited service. It's unfair to the group that got limited service to be randomized to that condition. And the analogy here is, the argument I get is, you can't randomize parachutes to find out whether parachutes work. We know. And it's unfair to people who are not getting the parachutes. Well, actually, there is a situation where you can randomize parachutes. And we should, maybe, when there's not enough of them to go around. And we have lots of lawyers and practitioners in the room. Could you please raise your hand if you have enough resources? Could you please raise your hand if you think that there is enough resources in the United States to give everyone with a civil legal problem full representation? And that we will ever see that day? I'm so far not seeing any hands raised at all. There is severe scarcity. So these are true stories that I've encountered. Some of them I've encountered personally. And some of them I've read about in the literature of how the legal profession reacts to randomized controlled trials. One was an RCT of mandatory domestic violence counseling for folks accused of domestic violence. Prosecutors were so convinced that the domestic violence counseling for defendants was important that they went and tried to get a court order to stop the study midstream. The study nevertheless survived. And it showed ultimately that the counseling did no good whatsoever in terms of reducing domestic violence rates or in any kind of recidivism. It is now virtually impossible to do an RCT of domestic violence defendant counseling across the country. Why? Because the law will not allow you to create a control group. In other words, after studies demonstrated the ineffectiveness of at least one type of counseling, it was universally adopted across the United States. That's how we react in law. Okay? Here's another one. Me personally, I was doing a randomized controlled trial with a legal service provider, and it was oversubscribed. You'll hear about it more here. The legal services provider was randomizing its potential clients to full representation or referrals to other organizations. Another LSP, legal service provider, heard about that study and abandoned its own priorities and intake system in order to try to prioritize the folks in our study that were randomized to no full representation, despite the fact that it was itself oversubscribed. In other words, it abandoned its own triage protocols and prioritized the members in our study in order to try to prevent it from occurring. That's how lawyers react. In a state court system, it only allows, in a state court system in the United States that I'm working with right now, will only allow me to do a randomized study on outreach to try to get defendants to show up to court if I promised not to find out what happens to those defendants when they got into court, because that would have been an evaluation of the court system, and they didn't want to be evaluated. Okay? This is how lawyers react to RCTs. Okay?
But it's not worth in medical trials in terms of consequences. It's not worse, more unfair to one group or the another if we don't know what works or if we don't have enough to go around. Final thing, it can't be done. It can't be done is another thing I get in law. Well, of course it can, and we're going to talk about some of the examples, and it's been done a lot before. And here's the one that I really get frequently in attempting to do this business. We already know the answer. Why are we studying something? Why in the world would we study something? We know what the study is going to say, right? Well, we didn't here, right, in this particular exercise that we just did. And we're going to try to show you, we're going to try to test whether you know the answer because we asked you to predict the results of actual studies. I never know the answer. I'm kind of clueless. But I'm routinely unable to convince lawyers that they don't know the answer. Furthermore, when we have RCTs, when we have gold standard evidence, lawyers and judges frequently just say, okay, now you did your RCT, thank you. Can we please go fund my program? Regardless of what the program, what the RCT shows. And this happened, okay, no, this is like lawyers that really don't have a clue. These are not, high prestigious lawyers. This is the chief judge of the Second Circuit Court of Appeals, the Federal Second Circuit Court of Appeals, who had settled some cases in a pre-argument conference program, wanted funding for it. The funding was with the condition that there be a randomized study. The first randomized study showed no effect whatsoever on a decrease in terms of oral argument rates, which is exactly why the chief judge wanted the study to work. And then the chief judge said, fine, you had fun with your RCT. Can we please fund my pre-argument program, my settlement conference program? Whereupon they said, okay, we'll give you another bit of funding. Let's do a second RCT. And there was a second RCT. The chief judge managed to kill it midstream, did not allow the second RCT to occur fully. Nevertheless, there was enough data to do something that showed that by a hair's breadth, it also failed, the second RCT, whereupon the federal government, the form of the Federal Judicial Center, published reports saying anyone that cares about decreasing docket congestion in the federal court system should look at this program that this brilliant Second Circuit judge has come up with. That's how we react in law, okay? I think that's bad, okay? Other professions, medicine, hormone replacement therapy. Everybody remember reading in the paper about this? Economics, making microloans to folks for economic development. Public health has recommended that teen and preteen girls be given robot babies to take overnight or over the weekend to simulate actual babies because they cry and do inappropriate things in the middle of the night in order to reduce teen pregnancy. Okay? Criminology, you may have heard, maybe you saw the TV program, was very successful, went 9 seasons, called Scared Straight. Okay? These things all have something in common. None of them work. Even though the experts in the field thought that they really did work. And if they're scared straight, it turns out that when you could put juvenile delinquents into a prison system and have prisoners yell at them in order to try to scare them straight, it's a spectacular way to increase recidivism rates. It really works pretty effectively. 7 out of 9 or so RCTs showed that that's what happened. Okay. Did you already know the answer? Is this me or is this you? I forget. Okay, did you already know the answer? In this exercise, in the exercise you took, we asked you to predict what would happen in some studies that I ran with something called the Access to Justice Lab that I'll talk about in just a moment. We asked you to predict the results of those. So did you already know? And so, because we didn't have a clue. We had no idea the results of the study we just showed you. Okay, and so we've run these experiments, and you've run one, and let's see how you did.
Okay. So one thing that we ask you is the effect of a precedent that changes in a case or versus the effect of a defendant that changes in a case. And let's see what you predicted. I actually don't know because my phone doesn't show this big enough. So you said, the majority of you, so that these triangles should have no effect, strong, modest. In red is the precedent, in blue is the defendant. So for example, here, most of you thought that the precedent, weak precedent, would have a modest effect. And I guess most of you thought that the defendant, wow, really? Did you know my experiment is published? So maybe you didn't know that. I did this same survey with law professors before my experiment was published, and they predicted pretty much the opposite. So they thought that they thought the president would be much stronger than the defendant. I mean, kudos to you, because that is indeed sort of what happened. But let me first tell you how we set this up. This was an experiment I did 2 years ago here at the law school with the FJC. We just heard something bad about the FJC, but the FJC has been very cooperative in letting me do studies with federal judges, and I had 32 of them for 1 hour working on an appeals case derived from a real international criminal case. It was a war crime case. And we gave them briefs, statute, precedent, trial judgment, the full thing that you would have in a real case, not in a real war crime case, but like in a real smaller case. And then we did a 2x2 RCT, 2x2 because there's not just one treatment, there are two that we randomly assign. One is the weak precedent, and the other one is the defendant personality, where one of them was basically a Serbian jerk, nationalist, no remorse, and the other one was a Croatian guy who worked with NATO and was nice. I'll see what that did. And, whoops. Oh, this is funny. There's something missing. But let me let me just tell you what happened.
Back to the actual slides.
No. There's a slide missing. So what happened was that the precedent had no detectable effect at all. So the conviction rates or appeal confirmation rates were the same for the two precedents, even though one said it shouldn't be affirmed, the other one said it should not be affirmed. But the defendant had a very large effect. So the nice guy was sent to prison 40% of the time. The not nice guy was sent to prison 80% of the time, which was a highly significant difference.
Sorry,
yes.
Can you just say again what the precedent variable was?
Yeah, we gave, so with the international setting, we basically withheld some of the really existing precedents. So we gave the US judges one of two precedents.
It's like an actual case or something?
Yes. No, there were real decisions from the ICTY, real appeals cases, and there are basically 2 or 3 of them that were on point, and we showed our participants only one of them. One of them happened to support the defendant. The other one happened to go against the defendant. So depending on which one we showed, the judges, that made no difference. But who the defendant was, that made a large difference. I'm happy to talk more about that later. I should say, by the way, when I talked to a scientist friend about this, he's a mathematician, biologist, and I said, this is what I do. And he said, this is great, but this hasn't been done? He just couldn't believe it. He just could not believe that this has not been done. So we did it, and we're doing more of this kind.
Okay, so then it looks like y'all predicted that one pretty well. Let's see how you did on another one, which was the effect of unemployment representation. You were asked a question that says that when law students assist unemployment claimants in unemployment representation mini trials, administrative mini trials, would the representation provide any benefit, no benefit, or would it be harmful to the claimants? There are several law students in the room, and you may have heard of this study, in which case you might have been able to predict it accurately. And so what did y'all think would happen? Is it Holger, can you show us what you think would? Oh, I see. Increases the chance. Okay, so I see what's again. You can see I got it. So it's up here. Many of you, so 78% thought it was increase the chance that the claimant would be found eligible for benefits, that the student representation would do that. And 22% thought no effect. So about 4 to 1 in favor of increasing the chance. And so the true results are. This is the study we did. Sorry, this is show. So we want to get at that question. What methodology do we employ to get at that question? And what we do is we take an oversubscribed legal services provider. Here, the Harvard Legal Aid Bureau. And the Harvard Legal Aid Bureau was oversubscribed, and so it did intake and determine eligibility, and then randomized some folks to get an offer of representation from the Bureau, and some folks to be referred to other service providers, on to other service providers. And in terms of what happened, the representation rate for the folks that HLAB took as clients was around 85-ish, 86-ish, maybe somewhere between 85 and 89%. The representation rate for people who were referred was around 37, 38%. So it made a big difference in terms of how many folks were represented. But the results were that it had absolutely no statistically significant detectable effect on the win rate. That this histogram here, the way to read this histogram is this is a difference in effective win rates. So if there were a very big difference, that spike right there would be all the way out to the right. And this histogram is showing you what were possible, the likelihood of possible outcomes if there were no effect whatsoever. And you see that the spike is right in the sort of in the fat part of the distribution. In other words, it's not statistically distinguishable from no effect whatsoever. But however, we did find something that was surprising to us. In the next slide, please, Holger, that you see this spike is way up over there, and the offer of representation from HLab did delay the unemployment proceeding, effectively multiplying the length of the unemployment proceeding by 1.4. So if you multiply by a number bigger than 1, something gets bigger. You multiply by a number smaller than 1, it gets smaller. This multiplied by a number bigger than 1, it slowed the proceeding down, which for most applicants for benefits is not what you want. And so there were questions that we were immediately raised. Our primary thought was not, is the Legal Aid Bureau's representation poor? Because we were interviewing judges in this system at the time, and they said, actually, the HLab students are the ones that are taking these cases seriously. They're the ones that are prepared. They always present the best cases. Our thought was instead that HLab may not be getting the right client base. That by waiting for folks to call it, it is instead getting folks that don't need its help. And so it needs to go find clients who can't find it easily, okay? Yeah, I'll just go really quickly through the next one then. The next one is simple divorce. No domestic violence, no family issue, no economic issues. Divorce, what did y'all think about that? And this is, so again, you thought, not as many of you thought that there would be as big a big an effect. Still some effect, but instead of 4-to-1, it's more like 2-to-1. That was your prediction, okay? And the truth is, in fact, go ahead. Oh, I have to do that. I see. The truth is, in fact, an enormous, humongous difference. And so again, this is what would happen. These little histogram thingies are what would happen if there were no difference. And there's about a 45 percentage point difference between folks who are able to file a divorce proceeding within 18 months versus folks who were not able to file based on whether they were offered representation from a service provider or not, and a slightly smaller, around 40 percentage point difference in terms of people who are able to terminate their marriages within 36 months, okay? So my suggestion to you is this is hard. I didn't know. This is really hard to predict ahead of time. And we lawyers have to get over the idea that we can and we know everything, which is where we are right now based on our prior anecdotes. The Access to Justice Lab, which is what I work with for now, has researchers. Many of you here are involved. It has about 85 law students involved right now trying to do RCTs in law. We try to persuade people to do them, and we try to implement them when we have them. And our scope is anything in the legal profession. And our goal is to try to transform law into an evidence-based field in the sense of doing these RCTs. Okay? And these are examples of studies that we run. Criminal, pretrial risk assessment scores, self-help, alternative dispute resolution, triage, any kind of legal service. We have RCTs in the field doing this stuff. They're saying it can't be done. We are just proving that right here today. Okay, and now we'd like to get to Chief Justice Gants and have Chief Justice Gants join us. So let's actually, Your Honor, why don't you and I come sit here so that everyone can see. Do we have the second microphone, or should we just pass it back and forth? Okay, we'll pass it back and forth. Your Honor, maybe you can. So thank you, first of all, very much for being here. We're quite honored to have you. Do you agree, which part of what we just discussed do you agree with? Which part that what we just discussed do you not agree with? In other words, is law as bleakly anti-evidence based as we portrayed it here, or are there some circumstances in which the legal profession is more receptive?
So I speak for all of law. And the fact of the matter is, it depends. Of course, is the answer to every legal question at Harvard Law School. We're quite happy to have you do your work, and indeed we encourage it. I do understand some of the concerns. When you were going over some of the critiques, some of the reasons people say no, two things come to mind. One is it matters, I think, whether you are creating a new service that is offering something that was not already offered, for which it is easier to do a randomly controlled study because you're taking nothing away from people, versus where there already is an existing program and you have to say they otherwise would have received this counseling, for instance, but now they are not. So it is easier to be testing where you say we are going to provide something that otherwise would not be provided, and we're only going to give it to some people as opposed to others. So I do understand the concern about saying we are going to deny people things that currently they have and otherwise would have, but for you, versus we are going to provide something that right now is not available, but we're going to make it available only to some in order to test its efficacy. The second thing which I do understand is that to the extent that studies are encouraged by people who want you to prove a point, you are a substantial danger to them because you may not prove the point that you hope they will prove. And one of the enemies of these studies is the extent to which advocacy groups get funding for such studies. And we, of course, as you know, had one in which people were very unhappy with you because the program was funded in part to demonstrate the importance of full representation. And your study didn't turn out that way, and that's your fault. Now, that study is sort of intriguing, both because it demonstrates that you don't basically bring in someone to do a study for the purpose of finding the answer which you want. That generates simply two things. One is tension between the researcher and the advocates, but also it leads to the danger that things are going to happen that are going to affect the quality of the results. So if you are evaluating, for instance, whether or not a program that takes young adults 18 and 24, and whether or not providing them with various programs are going to diminish their risk of recidivism, and if the answer that they need to have is yes, because their funding will depend upon it, one needs to look to see whether or not they're throwing a lot of low-risk offenders in order for them to look good. Because it's relatively easy to look good with such programs if you manage to understate the degree of risk of individuals involved, and therefore they can demonstrate that they're doing great things and are worthy of funding, but the fact of the matter is you bring in low-risk people and you do nothing or something, and they're likely to recidivate at a much lower rate. So I do understand that consideration, and I also do understand a third concern, which is it is easier to eliminate the variables when you're speaking about a drug than when you are speaking about a court system. Life is very complicated. People are very complicated. Even precedents are complicated in terms of the extent to which you describe their strength. And the extent to which somebody is a good person or a bad person is not necessarily easily a 0 versus 1 variable to place on it. So I know that there are, we hear it all the time with regard to we upstairs in our Crystal Palace don't understand what goes on in the field. And we've all been in the field, or most of us have been in the field. But I'm sure people would say even more so that you pointy-headed Harvard types trying to come and understand what goes on in terms of all that occurs in a busy district court are not taking into account all the variables. So, so there is certainly going to be resistance to results that people do not like. And I do understand that the source of that resistance is going to be, well, they didn't fully understand the complexity of what we did. They tried to make it simple, and they failed to account for all the variables that actually should appropriately distinguish the success of some individuals from others.
Mm-hmm. Terrific. You have been a thought leader in this area in terms of taking into account and actively seeking rigorous evidence and rigorous empiricism in order to inform policy at the judicial level and judicial practices. What is an example? Take the criminal law arena first, and then I'll ask you the same question on the civil side. What is an example of a problem on the criminal side that you think would benefit from rigorous empiricism and that you would like to see rigorous empiricism deployed in order to help solve?
Many. In part because one of the most serious questions is with regard to sentencing and with regard to bail. So we know there are a number of states which are aggressively using risk assessment data generated largely by the Arnold Foundation, and it would be helpful to know whether or not that actually does diminish the risk of new crimes or the risk of return. That, for instance, the use of that data itself generates its own concern. There are two concerns there. One is we can't use in Massachusetts the Arnold risk assessment study because when you go into the algorithm for it, which is proprietary and we don't know much about it, which itself is a problem. It's a bit of a concern for us if defense counsel say, I'd like to see the algorithm, and the answer is, sorry, we won't give it to you, which invites, as one particular judge said at the Conference of Chief Justices, you know, why did you release this person? Because Watson told me to. And that is a bit of a concern for a court system where you are relying upon Watson or the equivalent. The other concern with regard to Arnold is there are three major variables. One is the prior failures to appear. The second is whether or not you committed crimes of violence, and the third, whether or not you have committed any particular crime. So they're measuring risk of violence, they're measuring risk of reoffense, and they're measuring risk of flight. Under our case law, we do not permit risk of violent offense or risk of a new offense to be considered in the absence of a due process hearing, which this does not give you. And Arnold will not basically separate out the other two and give us merely the risk of flight data. So there is part of the problem is, okay, we can do this, but not, and we have to therefore create our own. So we would love to do it with regard to bail. We would love to do it with regard to drug courts. We'd love to know whether or not the drug court model, the mental health court model, the veteran court model truly is effective. They actually cost us a fair amount in terms of clinician and probation assistance. And if they're not going to materially reduce the rate of recidivism or not going to be cost effective versus other alternatives, then perhaps they're not an ideal model. We would also love to be able to get some sense as to how to reduce the rate of recidivism in terms of various programs, whether it be putting a GPS bracelet on somebody. So recidivism turns out to be one of the easier variables to do. The problem is it takes time because you have to wait 3 years to see what actually happens, and you need to be very careful in terms of how you measure the rate of recidivism. I've seen many, many reports on the rate of recidivism. It matters a great deal if you say, what is the likelihood the person is going to return to jail? Well, that could be because the person may return to jail because the person has committed a new crime, or it may be that the person has returned to jail because you have probation and parole, which will pull the trigger on somebody for very minor non-criminal violations. So the extent to which probation and parole people are quick to return people to jail can materially affect risk of recidivism. But in any event, you're always welcome in Massachusetts. If anybody else, I mean, it's certainly, your record here is about 1 in 20. We would generally say yes if it if it is a study which we think can actually affirmatively help us with regard to the answer, and I've had many discussions with a whole lot of folks to say if you bring in Professor Greiner, you have to recognize that he will do what he's supposed to do. That's his job. So if you bring him in for the purpose of getting the answer you want, then you need to be aware that that may not be the result.
Terrific. Let me ask you the same question on the civil side. A set of one or a set of issues that you think on the civil side could be particularly benefited from rigorous empiricism.
Well, the one that you have already focused on, which is we are triaging legal services because there is a woeful lack of money in that particular area. It is not likely to get better, at least with regard to federal aid in that regard. So the question of to what extent does legal assistance matter as opposed to self-represented assistance, and what kinds of things there matter are all terribly important to us. So we are glad to have you be involved in this research, because the fact of the matter is we have very few resources and we really can't afford to squander them, and therefore the allocation of those resources in a sensible way matters a great deal. So, I mean, one example is debt collection, which I know that you have been involved with. About 80% of people don't show up with regard to it. Those who do show up and get legal counsel almost invariably win, because the fact of the matter is most of the defendants have purchased these debts for 5 cents on the dollar. Exhibit A, they're often securitized, and when you actually say, show me the paper, they rarely can actually say that they actually have the paper they need to prove it. So there's one recent graduate of law school who is right now doing this work. He said, you know, I'm not that great a lawyer, but I haven't lost in 6 months. Now, can we do that with regard to all people? Maybe, but of course, if 80% aren't showing up, you're only focusing on the very small percentage of those who do, and then you have to wonder whether or not there's a reason why they showed up. So, the issue of how we can best allocate terribly scarce resources to provide appropriate results matter, and that's another tension, which is what success is in the legal service community may or may not be viewed as what success is in the judicial community. So, you know, I wear two hats here. I'm Chief Justice of the Supreme Judicial Court, but I'm also co-chair of the Access Justice Commission. And when you're focusing on success with regard to those who are advocating for the poor, you have different measures which the court system can't necessarily adopt. So in a housing court system, you may view success to be the extent to which tenants are allowed to remain in their homes and maybe even or pay less in terms of back rent, or even maybe be able to have counterclaims which would permit them to be obtaining additional funding, but that can't be the court measure of success, because the court has to be fair to landlords and tenants. So that's another source of tension in terms of who are you working for.
Final question, and I'd like to open it up to the audience for questions and thoughts of any kind. Chief Justice Gants, to the extent that there is an issue with resistance to rigorous empiricism, those of us who care about such issues need to message things properly. We need to persuade the United States legal profession that rigorous evidence is not a fundamental threat to the profession. In fact, it's a tool the profession should use. The court system, it's not a threat to the way the court system runs. In fact, it's a tool the court system should use. How should we structure that message in order to be effective in terms of persuading folks to engage in rigorous empiricism?
Two thoughts. One, the single most effective way is to say that another state has done it. The fact of the matter is, Brandeis, as in so many matters, was right with regard to this laboratory of 50 states. And I know that one thing that has emerged over the last 20 years is the extent to which there are national conferences in which people come. And I know it matters because I've been at these conferences now for 10 or 12 years in the area of access to justice. And 10 or 12 years ago, you could identify on one hand the number of states which had court service centers or were using unbundled representation or doing things which were at that time viewed as innovations in that area, and now you need 6 or 8 hands to be able to count the number of states which are doing it, because states are copying each other. So the extent to which another state is doing something and has managed to survive it and survive your presence there is one source of comfort with regard to it. The other part is, I think, a matter of something that you perhaps can't do that much about, but it is a question of culture. Former appeals court Chief Justice said, and I quote him a lot, I'm not sure who he quoted, but which is, everybody loves progress, everybody hates change. And the fact of the matter is, what you are doing is threatening to people who've done the same thing for quite a long time. And are very comfortable doing it. They know how to do that. They have to justify the fact that it must be right because they've been doing it for the last 5 or 10 or 15, 20 years. And you threaten that vision. So having a culture which says we need to rethink how we are doing things, we need to focus on things we are doing well and things we are not nearly doing well enough, and be prepared to receive the information we need to determine whether or not new programs help or not, matters a great deal. So I mean, I can say that we did. Sanders is in the back, and she probably knows more about it than we were. Quite gung-ho at one point in time with regard to a program for high-risk offenders that began in Hawaii, known as Hope Board. There was a judge in Hawaii who basically focused on tough love, which meant that every time somebody violates a condition of probation, they bring them in and give them a day or 2 or 3 in jail and say, okay, go out and don't do it again. And they had impressive results in terms of reducing the rate of addiction and the rate of recidivism. It seemed like this notion was one which had proven to be successful in Hawaii. And so they sought to expand it to other states. We had a pilot program ourselves in the area of Lawrence, and it turned out that data demonstrated it had no particular success. And we did not ignore it. It was a bitter pill to take because it seemed like such a good idea. But the fact of the matter is, it did not work. It was not a terribly sensible investment of our resources, and now we are rethinking it. And indeed, it goes more broadly because this notion of tough love with regard to criminal defendants, which is one which many judges thinks is the kindest thing to do, there's now a new view that perhaps that's not the kindest thing to do, that perhaps the kindest thing to do is to impose as few conditions as you possibly can to provide some leeway with regard to the extent to which people are going to violate those conditions, especially when those conditions involve the use of drugs or alcohol, where relapse is to be expected to some extent. And that is, again, part of people revisiting what they had done. So, but you need a culture which is willing to say that's okay.
Joanna, if I may follow up on that last point, I think that demonstrates, by the way, why Chief Justice Gants is a leader in this area of trying things out and trying to get data. Isn't that something that could be generalized? You said, I think rightly, you can't take things away from people. It's hard to take them away from individuals, deprive them of that, but also people who have been running a program for a long time. They are invested, they don't want to give this up. But we open up new programs all the time. We change things. And usually at that moment, there's a faction that advocates the change, and another one that is against the change. And maybe just for budgetary reasons, but certainly not in favor. And so it would seem to me that one way to compromise could be say, well, let's do a trial. We call it a pilot in Lawrence. You could call it, don't have to say RCT, but that's what we would be doing. And then we'll just see what the results are. We'll take it from there, and if it looks promising, then we'll roll it out. But if it doesn't, then we won't roll it out. Then both sides can believe that they are going to win this fight because they both have their priors on what they think the outcome is going to be. And that would seem like that should be politically attractive to all sides. But apparently it's not in practice because we don't see it very much.
Well, we do a lot of pilots. The great joy of a pilot is you learn, you adapt, you change. But it's also true that those who, one thing that a court system has everywhere is too few people and too little time. So when those are engaged in developing a new project, it may not be their day job, and there is a certain cognitive dissonance that gets involved, in which you are investing a lot of time and effort in creating a new program, and you hope to hell you haven't been wasting your time. And so you're prepared to have it to be measured, but you certainly hope it turns out to be an investment that is worthwhile. I mean, there is one good example of it is with regard to the drug courts. I mean, there is a fair amount of data with regard to it. I have not studied it carefully enough to know to what extent it is credible, but a whole lot of people believe in drug courts. A whole lot of judges invest an enormous amount of emotional energy with regard to their relationship with the defendant in drug court is a very different relationship. I never went to a defendant's funeral, and I know of no judge who did before. And now there are dozens of judges who are in drug courts who are going to the funerals of defendants. That is part. And a drug court judge's view of it is that I lost somebody. That is a whole different emotional investment. In cases you really would hope that that emotional investment is producing beneficial results. There is some data to indicate that it is, but you can understand the resistance to something that is going to say that all of this investment of time and energy and emotion turns out not ultimately to be something which is producing results. That's a hard thing, and it's a hard thing to deal with. Since we're being taped, I'm not suggesting that drug courts are not worth the investment, and indeed we are involved still in studying that, but it is only by way of example of understanding the degree to which there's a lot of blood, sweat, and tears that goes into these programs for a whole lot of people, and you can appreciate the fear that someone's going to, some Harvard professor is going to say that all your blood, sweat, and tears were in vain.